Wait, back to mention item number 5.
Right.
Wrong document has been filed as elector 7. So I
Okay.
may be allowed to withdraw with liberty to file again.
Mr. Deepang, learned counsel for the petitioner submits that he may be allowed to withdraw this petition with the liberty to file a fresh. Praise the Lord. The petition stands closed on withdrawal with a liberty as straightforward.
May I, Your Lordship? Your Lordship, I beg to mention item number 7, Your Lordship.
7, yes.
On behalf of Ms. Gieta, Your Lordship. Due to some personal difficulties, she is unable today, Your Lordship.
What is the matter?
Your Lordship,
Compensation matter.
You are there?
I'm there.
Okay. No objection.
No one.
On the prayer of Mr. Wairidam, learned state counsel for the respondents, and prayer not being objected to by Mr. Deepang, learned counsel for the petition, as well as Mr. K. Lawyer, learned counsel for the respondents.
1, 2, 4.
Come on, list this matter up to 4 weeks.
One.
4 weeks.
obligations.
May I please, Your Lordship? My Lord, with regard to item number 26, I have filed a rejoinder today. I may be allowed to bring it on records.
26.
That arbitration,
Huh?
there is a delay condonation in arbitration appeal.
Hmm.
That day, my Lord, because of some technical difficulties, I could not appear.
Yes, yes, yes,
I may be allowed to bring it on record.
yes. This is, okay.
May it please your lordship. Lordship, I would like to mention item number 29. Your lordship, this matter may be taken after.
Why? If this policy doesn't apply. Have you read that policy?
Yes,
You have not annexed the policy.
Policy for
They have annexed it. You have not
Yes, they
annexed it.
at the filing of the petition.
Therefore, there's nothing, it doesn't apply. We feel for you that your husband met with an accident while on duty. There must be some other thing. Because this clearly says killed or permanently disabled. or
While during
grievous,
performing duty, that unfortunately.
law and order. Law and order. While fighting with the terrorists, militants, and law and order. I think it prima facie doesn't apply. Sure, that is your only basis.
Yes, lordship.
There must be some other thing.
So in meantime, I'll see your lordship, any other provision is there.
What
to-
other provision? Your only claim is that only. Under
At
that,
the time of filing
under
the
that only.
petition, we don't have that guidelines. Only recommendation made by the deputy commissioner.
Have you not applied for compassionate appointment?
Compensate appointment was made,
She has been
yeah,
appointed.
yes.
Be happy with that. Because this policy doesn't apply. So it's not a law and order problem. I mean duty.
Or I-
You are on normal duty.
I'll inform the petitioner and in the next hearing that I'll do the
It's
dispose the
better.
matter.
Unnecessary, don't get dismissal of the writ petition. Only Mr. A. Bhattacharya, learned counsel for the petitioner, submits that he may be granted sometime to obtain instruction in view of the fact that the policy of the state for grant of ex gratia prima facie appears to be not applicable in the case of the petitioner, in the present case. This after 4 weeks, 3 weeks, 4 weeks, 3 weeks, make it 3 weeks.
Much of like.
Lordship, I beg to mention item number 19. Services on awaited so.
Why you want to rush? Be there, we'll see. You be there.
Service is not completed upon the respondent number 4.
So you are going somewhere.
No, no, I'm not
We'll
going.
see. We'll see. You be there. We'll see.
My lord, I beg to mention item number 9.
9.
Yes, my lord, on behalf of
Yes.
Tita Pak, my lord.
Hmm.
I consent from other parties, sir.
What is this?
Yes, my lord.
What is the matter?
And not ever, my lord. Not ever, my lord.
Be aware. Give the second copy. We'll see.
Termination from service, Your Lordship. Termination from service.
Have you completed? You have filed the affidavit
Yes, Your Lordship.
of what post?
Anganwadi worker, Your Lordship.
Let him aware of the matter. Yes, next. We're not adjourning. You read it.
May I, my lord, I would like to mention item number 10. Your Honor, matter may be listed after 3 weeks.
Why?
Due to
Malada, it may, I'm not, objecting to the adjournment as such, but it may be fixed for some admission hearing. We have urgency, man.
What is the matter?
This is matter, my lord, in our legally allotted plot of land, he is occupying behind some, occupy some government land, man. He started constructing road and other things in our allotted plot of land. So God, DC said, you cannot do that one. Against that order they have come.
Okay.
Now, because of pendency of this matter, my lord, if we want to do any construction, they say matter is pending before High Court, you cannot do anything. That's
We're
why.
disposing on it. Are you aware of the matter?
no, Your Honor.
So give the second file. We're disposing of the matter. We'll see if you have some inconvenient, we'll see. But read it and we'll let us try.
Lordship, I beg to maintain item number 12. I'm
12.
petitioner.
What is the matter?
Leading counsel could not able to.
What is the matter, sir?
Against of the influence of the regarding of house fire.
House fire?
Actually, Your Honor, my friends just engaged me.
Give him the second file. Read it and we'll see.
I would like to mention item number 11.
Item number
11.
11.
Say, the Connecting Council is out of station.
Hmm?
The Connecting Council is out of station.
What is the matter?
I will be acquainted with it.
Huh? You be acquainted. Give the second file. We'll see. No issue.
I have not found any order that.
Well,
Well,
it's a
in-
notice. Take
But-
with the pending matters.
My lord, I am praying for stay, my lord.
No, we'll say, what's wrong? Let them be, we'll say that,
My lord, how can there be, my lord?
no final decisions.
There is a
Taken
division
without-
bench,
Without the,
there is a division bench decision of our High Court, my lord,
Okay.
that says that there cannot be a parallel proceeding, my lord.
it's all right. We'll say that no final decisions will be taken
My
on the
lord may-
basis of the
my lord may say-
committee's report.
Yes, that they will not act upon any report then.
No
On-
final decision, no, not to
But the
take-
whole writ petition, the earlier writ petition was before this lordship on the ground there that earlier subcommittee report has not been acted upon by the government. We have filed an affidavits that it is correct why it has not been acted upon for such and such legal reasons.
Okay.
After that, my lord, they have, my lord, done this, my lord.
Where is the constitution? Where is the constitution of the committee?
At page 226.
226. These are respondents.
Yes, 6 to 8.
Sixth, on the basis of the representation by.
They were made, junior, below they were placed below you,
Yes,
and then that has been put to challenge.
yes,
It's pending.
yes.
By them.
And the main ground in the writ petition is there is a subcommittee report wherein the rota quota was, my lord,
That has not
Uh,
been accepted.
that has
by
not
the
been accepted by the government.
government.
Now, there's a proceeding pending before Lordship. Your Lordship is in the session of this matter.
Yes.
There's a direct division bench judgment of
Yes,
this
yes,
honorable
we
court.
know. Yes. Anyway, we'll let us see. It may help us also to decide the matter. Let them examine. And we'll say that not to take final decision. Not to take final decision.
On any report that will be
On a
submitted.
report
by
may
this
be
court.
submitted
Yes.
on the report. Without the leave of the court, we'll
Yes.
say. That will be-
Otherwise, my lord, we have filed our affidavit, my lord.
It's all right. We'll see. We'll take this matter along with that pending matter. Huh?
My lord.
No affidavit is also required here. You may in the
Yes,
meantime, you
yes.
may file.
Yes.
Okay. Heard Mr. Deepak counsel for the petitioners. Challenge made in this writ petition is to the order dated 30/05/2025, passed by the Commissioner HPD, bracket clause, Government of Arunachal Pradesh, whoever on the representation of the respondent, private respondents,
Yes. Six
Uh,
to eight.
6 to
Eight.
6, 7, and 8, namely so and so, you write their name, huh? It's page 2 to 6, huh? On the joint representation submitted by so and so, you take the name, you write the name, comma, respondent number 6, 7, and 8 hearing. A committee is constituted to examine the issues raised in the joint representation as contained in the subcommittee reports dated 23rd June 2020 and 29 April 2025, and to submit recommendation. Mr. Mr. Deepak learned counsel to the petitioner. Petitioner submits that.
Petitioners.
Petitioner submits that since the issue is in session of this honorable court, no parallel proceeding would have been initiated, which would directly against the settled proposition of law. In the case of what?
Akadas Ali, my lord.
Uh,
For State of Assam, 2014 Ford GLR, page 3.
you just give. Report so and so, so and so. Therefore, submits that the committee, the order constituting committee maybe is required to be interfered with. Mr. Issue notice returning by. Issue notice, we'll just say issue notice. Mr. As Mr. Estafin, senior government advocate, enters and accepts notice on behalf of respondent number 1 to
5.
5. No formal notice need be served. However, extra copies need furnished to the Then counsel for the petition to take its steps for service of notice upon respondent number 6, 7, and 8. Where is that question and session? List is better. No. Next paragraph. Having considered the submissions and in view of the settled position law, since the matter, since the issue sought to be examined by the committee, by way of constituting the committee is pending before this court. The no final decision be taken in the event the committee examines and submits report without the leave of this court. List along with, and list the matter along with
WPC 295, 2024,
295, 2024.
WPC 14,
Hmm.
2022, WPC 459, 2022.
Three writ petitions. Okay.
Main is 295.
It's okay.
All right.
May I please, Lordship?
What is the rule or the act which provides the tenure of post transfer and posting?
Lordship, is at Lordship guidelines framed by the Education Department is at phase, it starts from 30 to 41. And the operative portion is at page 34, clause 9, Lordship. General guidelines for transfer and sub-clause 3, Lordship. Minimum service period in a school for seeking transfer shall be 3 years and maximum service period in a school shall be 5 years.
But then within capital only.
But then, Lordship, it's involved a movement from one place to another and the petitioner is subjected to frequent transfer, Lordship. Lordship, on previous occasion, I have been transferred within 3 months. And now this time also, I have just completed 15 months only.
Seeking transfer shall be.
And these provisions, this is regarding the any employee who submitted any application for seeking their transfer. But in my case, Lordship, even I have never submitted any representation seeking my transfer, Lordship.
Or otherwise, what is the normal tenure?
Normal tenure is 2 years, Lordship. I have enclosed the government circular also as page 41. It was issued on 18 August 2021. The normal tenure has been fixed 2 years at particular place of posting.
So,
My lord, as my lord had already pointed out, my lord, this is within the capital only, my lord. Within capital region only, from one school to another school. This is internal arrangement, my lord. Not strictly transfer.
where is the impugn order?
Impugn at page 29, Lordship. 29.
Why not, why two of them only?
Yes, Lordship. In the interest of school administration and need base, the reshuffling of following head teachers within Deputy Director of School Education Capital are hereby made against the schools indicated in column below.
Reshuffling.
Reshuffling, not even
The word language is reshuffling, but Lordship, I have been transferred and posted from C sector Itanagar to Nyors.
reshuffling.
First transfer.
First transfer, Lordship, is at page
First-
24.
Partial, this is also partial modification.
Page 24, Lordship. Is the first transfer where I have been transferred from Senki Park, Itanagar to
You are just rotating here only.
rotating
Within region.
only, Lordship, in my case only, Lordship, but rest of the head teachers,
Why you
They are-
don't want to come to Nyoj?
Lordship.
Why don't you come to Nyoj?
Lordship,
Why don't you don't want to come
yes,
to Nyoj?
applicant petitioner, Lordship,
It's
is
better.
a old age.
You'll have a better environment, clean air.
Correct.
Nyoj here only.
Yes,
here
here.
only.
She having
It's a
permanent,
better place.
Lordship, she is having permanent residence at Itanagar, so it will
Doesn't
be
make a
difficult
difference
to
how far
attend.
it is.
And she is an old lady, even she could not
Your learned colleagues coming from Itanur every day, beyond Notch,
Without
crossing the
leaving
Notch.
without leaving the station, they can attend the.
You don't have to bear the traffic, traffic congestion. Otherwise, it's a better place, beautiful place.
Her health does not permit also.
Sankey Park.
Yes, Sankey Park.
It's there is a park, therefore you don't want to live.
Right now, I am posted at C sector Itanagar. This is first
So it's more
initial
crowded.
transfer, Lordship. Then subsequently, after 3
So
months,
according to you, this guidelines is for those who seeks transfer.
yes,
Then what is the normal tenure which, what is the guidelines which regulates the normal tenure?
normal tenure at phase 41, 2 years, Lordship. This is for a general, generally applicable in the state of FE, but for education, even on Freer only. Otherwise, Lordship, the
Otherwise,
normal would,
you cannot be transferred.
yes, normal would be 3 years, Lordship.
2 years or 3 years.
2 years in education department. But
Okay.
in general, Lordship, it's 2 years at phase 41.
41 says so. Yes. Where is the page 41?
Phase 41, it's
So regarding the transfer posting category of states.
earlier it was 3 years, but by this circular, it has been modified.
Officers and staff, including the teachers.
Yes,
Hmm.
Lordship. It includes, Lordship, all the government staffs within the
Teachers.
state of Arunachal Pradesh. Teachers
So
also.
general guidelines. Madam.
General guidelines.
Is it applied to the teachers also?
Madam, the teachers will be regulated by the teacher transfer posting madam, guidelines 2021, 19 to 20, yes.
Is 30.
That,
Yes,
I,
yes.
that I have annexed.
So then
That is.
what is the normal tenure?
Normal tenure would be, madam, in case of this internal reshuffling is different, but if it's transferred in a routine transfer, madam, at least 3 years,
Where
minimum 3 years.
where do you get it?
Madam, page 34,
Hmm.
clause 9,
Minimum service period in a school for seeking transfer shall be 3 years.
3 years, madam.
He said it's only if a teacher seeks for a transfer, then you will have to be there for 3 years.
Madam, that is, madam, whether the teacher seeks or whether by an administrative action, even if it is initiated from the department show motto, madam.
It should be
3 years, madam,
3 years.
rotationally, madam, yes.
Heard Mr. K. Learned counsel for the petitioner. By filing this writ petition, the petitioner has put to challenge the order dated 16/06/2025 passed by the Deputy Commissioner, Eternal Capital Region, whereby the petitioner is sought to be posted from GUPSC sector Itanagar to GUPS Notch by way of reshuffling vice respondent number, vice Siri,
Respondent number
because reach respondent number
4.
4. Mr. K. Learned counsel for the petitioner submits that the petitioner has been subjected to frequent transfer as the petitioner has been last posted,
Yes,
first where? 9 January
9 January,
to where?
from Sinki Park to Lordship, 24, phase 24, Lordship.
What I said is in his version,
See, sir.
huh? From why the posted at GPS Sankey Park by the order dated 09/01/2024. And then,
And then by transfer order 5/3/24,
and thereafter,
within 3
by the
months.
order dated 05/03/2024.
03/24. I have been
Posted to
posted to
GUPS
GUPS,
C sector Itanagar.
Itanagar.
Before the completion of normal tenure of 3 years. He submits that there is no public interest or administrative exigency in transferring the petitioner by the impugn order. What is the ground, other ground?
Other ground, no, Lordship.
Nothing.
Nothing, Lordship. Of course, I could not annex any documents, but on inquiry, the respondent authorities had verbally informed me that there was a pressure from the local MLAs and politicians.
Merely.
I have made a specific averment.
Merely at the behest of the local MLA to accommodate the respondent number
4.
4, which cannot be, which is not permissible under the law. Next page. Issue notice, no. Mr. Tita Council, Standing Council for the Education Department, while refuting the submissions of Land Council for the petition, submit this. The impure, the order of the impure order, in fact, is not a transparent posting order in a strict sense, but a mere reshuffling within the capital region.
Yes, man, it's local internal arrangement within the capital region.
Reshuffling, no, but an internal arrangement within the capital region by reshuffling list. Next one. Issue notice returnable by 4 weeks. As Mr. Titagum, Land Standing Council, Education Department, accepts a notice on behalf of respondent number 1, 2,
3, man. 1, 2, 3.
1, 2, 3. No formal notice. Need be served. However, accept office petitioners to take steps for service of notice upon respondent number 4 by register for so. Not on interim prayer. Considering that the having considered the submissions of considering the submissions of learned counsel for the parties and considering that the petitioner appears to have not been completed a normal tenure and she has been subjected to posting twice within a period of
15 months.
15 months. Within a period of 15 months. As well as considering the all these guidelines. Considering the
Page that.
teachers transfer and posting policy 2019 to 2020, which provides for minimum service period in a school to be 3 years, comma, in the interim. The appeal order dated 16/06/2025 shall not be given effect to. Shall not be given effect to. You have filed a representation.
Yes, Lordship. Page 42.
42,
Yes.
43.
43 is the typo.
Having considered that the petitioner has filed, has submitted a representation dated 19/06/2025 before the Deputy Director of School Education. Why don't you file a petition before the Deputy Commissioner? This has been issued by Deputy Commissioner.
No, Lordship, but signing authority is the DDSC, Lordship.
No, sign.
Approval in the district internal arrangement, DC.
May file representation before the Deputy Commissioner, Eternal Capital Complex, Eternal Capital Region.
Yes,
Mm.
Naharlagan.
And if and in the event any representation is filed, pendency of this report shall not be barred to consider the representation of the petitioner. List of the 4 weeks.
Deeply obliged.
May your lordship.
You have been transferred.
No, your lordship. This is a compensation,
Huh?
compensation matter.
Okay.
Your lordship, I have submitted a representation which has not been disposed, your lordship.
Has it been acquired under what law? Land has been acquired under what?
Lara Act, your lordship.
Huh?
Lara Act, your lordship.
So what is the provision?
Provision is, your lordship, I have to write a representation to the concerned deputy commissioner.
What is the provision? What is the representation? What is the question of representation?
Your lordship, it's, I have annexed in page 17, your lordship. They have,
No, what is the provision under the law to file a representation?
your lordship, I have not brought that
What is the law?
section. Your
This
lordship,
land has been acquired under
yes, Lara Act.
2013 Act.
Yes, your lordship.
So what is the provision in case of,
Your lordship, in case of that, the aggrieved has to file a representation, your lordship.
where is the law? Tell us.
Section 64, my lord. Of the Lara Act.
May I read, your lordship?
Hmm.
Any person interested who has not accepted the award may by written application to the collector require that the matter be referred by the collector for the determination of authority as the case may be, or whether his objection to be the measurement of the land, amount of compensation, the person to whom it is payable the rights of rehabilitation and resettlement under chapter 5 and 6 or the appointment of the compensation
So
among the person interested. Your
where is the representation?
representation is your lordship in annexion number
Written
16.
application to the collector.
Annexion number
Have
1.
have you sorted for reference?
Yes,
Where,
your
where
lordship.
it is? Where it is?
Page 16. Annexure 1.
Your name has not been included.
Yes, your lordship. Your lordship, fact of the case is that I am a resident of East Caming district, and this Chennai's number 123, 125 to 123 falls under the jurisdiction of East Caming. But then it has been assessed by the Kurungkume district, your lordship. I was unaware about this assessment because it was being assessed by the Kurungkume district. So of lately I have known that my land has been assessed. They have acquired it, but my name has not been enlisted. Therefore, your lordship, I have submitted a representation to the Deputy Commissioner Kurungkume for carrying out verification whether my land has been taken or not. And as per the recommendation board, verbally I have been told that my land has been acquired, your lordship. So there has been some technical error. And I am not against the construction of this road since it is of national importance and it's
You cannot
important.
be also.
Yes, your lordship. So what I'm only praying is that your
You cannot
lordship verification may be carried out so that. And I'm
No, that will be, it has to be referred to the authority.
yes, your lordship.
Authority will decide.
I am told that your lordship by tomorrow or day after tomorrow, by Monday they are going to disburse the amount. And if
When did you
the-
file this petition?
it's on 18th, your lordship,
18 of
06.
what?
1806 this month only.
So there is a 1 month
Then
time to make the reference.
they have published an order, your lordship, is annexion number 1A17, wherein they have said that by the 23rd to 24th, your lordship, they have already published the name of the beneficiaries, your lordship.
Can you be said the person interested?
Yes, your lordship, I did not get it.
Yes.
But this writ petition is not maintainable. In fact, my lord, if there is any dispute on the award has to be as per this annexure 1A. Award will be published on for public display on 23rd to 24th June. If his land is being awarded to someone else, he has to make a complaint, claims and objection. And here in what the recommendation board says, they will try to resolve it. If not, they will send it for reference. May I read, my lord? In continuation of order number so and so, the following directions and modifications are issued for smooth and transparent dispersal process of frontier highway compensation. The disbursement board is hereby renamed as recommendation board for dispersal. The composition of board so and so. The chairman of the recommendation board may requisition any required officer so and so. All recommendation boards shall publish the final award list for public display on 23rd to 24/6/2025 without fail. The recommendation board shall collect the documents of interested parties from 25 to 26 so and so without fail. The recommendation board shall collect the following documents from so and so so and so. The recommendation board shall verify the genuine identity of all interested parties and recommend final names along with requisite documents including.
This is under process.
Yes.
Yes, your lordship, that is
There
under process.
in serial number 7, a consolidated list of claims and objections
Yes.
filed with the deputy commissioner's office shall be shared with the recommendation boards. The boards shall hear these matters and provide final recommendation for disposal. Additionally, the board may recommend for referring unresolved
Unresolved
title disputes to competent reference court.
Yes,
They are following,
they are
madam,
taking care
and
of it.
clarify that all interested parties that any party dissatisfied with the compensation may choose to not to receive compensation and appeal to the reference court. They receive it under protest and appeal to the reference court.
Yes.
Now, if they will exercise, try to resolve,
Yes. Your
If
case
not-
may be considered also.
yes.
Yes, your
Why
lordship,
around 26?
I have gone through this, your lordship. However, I have appeared before this court for mandamus, your lordship. Since I have gone through this, they are going to do it. But then in case, your lordship, that will lend me to civil litigation, your lordship, if my representation
Want
is
to
not
have a shortcut bypassing all the statutory provision.
your-
Then
In that case, your
Sorry.
lordship, direction may be passed to dispose of my
what's the
representation.
question of the direction to pass, because they are taking care of everything. We are coming on today, they will done it by 28 June. And if unresolved and undisputed ownership and the titles are there, it will be referred to the reference court or the authority.
That I agree, your lordship, but
If you agree, nothing.
in fact, prior to.
Either you withdraw or
In
will
fact, how
dismiss the
this
petition.
honorable court will decide the title between this
Your
petitioner
lordship,
and the other person.
what I am praying for is your. in
See,
fact,
your
yes.
representation is under consideration. They are yet
Yes.
to take the decision. There's a board, they have constituted instead of reference.
Yes, your lordship.
The final order, by final award will be published tomorrow, 28.
Yes, your lordship.
So how can you preempt?
Yes, I am.
Either you withdraw it or we're dismissing your writ petition.
Your lordship, what I am humbly submitting is
No,
that
no.
my representation, prior to their order, my representation has been submitted, your lordship.
So what? That's
I
why
have
they
a-
are considering. How
You-
can you be, they take them a prompt action?
Your lordship, I have
There's
a
a procedure
apprehension
to
that,
be followed, sir.
I have a apprehension that my representation will not be considered, your lordship,
Your,
because.
we'll see if you're, you have a, in future, nobody will stop you.
Yes, your lordship. So only my representation, it could be that,
No.
on merit, it could be, if it could be, your lordship.
Sir, they are taking care of everything.
Yes, your lordship.
They are yet to pass the final order, award.
Only representation,
No,
Take
that
care.
cannot be.
to take care of representation.
How can we do that?
Deeply obliged, your.
What? Withdraw it.
No,
Withdraw it.
I will withdraw it. Your
Ah.
lordship. Yes.
Heard, Mr. B. R. Raksap, learned counsel, B. Raksap, R. Raksap, learned
Yes.
counsel for the petitioner. Not heard, Mr. R. Raksap, learned counsel for the petitioner. Having realized that the representation while before the district, the claim of the petitioner is being considered by the board.
Recommendation board.
Whatever, recommendation board by the order dated 20/06/2025 passed by the Deputy Commissioner, Kumla District, phrase that the fairly submits that he may be allowed to withdraw the writ petition. Mr. Accordingly, writ petition stands closed on withdrawal. A prayer is allowed and placed accordingly, writ petition stands closed on withdrawal. Mr. No, before that, Yusuf, Mr. N. Ratan, London Additional Advocate General is present. He appears for the state. Then you're right, having considered the submissions and considering on the perusal of the order dated 20/06/2020, which reflects that the claims of the interested persons, including the petitioner, appears to be under consideration by the authority. The prayer for withdrawal is accepted, Accordingly, this stands on withdrawal.
All right.
Your Lordship.
Yes.
Small.
What is the eviction orders? Any eviction orders?
No, actually, it is not regarding eviction, my lord. It
Ah.
is regarding, my lord, actually, we are there. We are already dwellers of the reserve forest, my lord. In fact, we are having our forefathers, ancestors, we are having this village, Jipu village, since Nepa days, my lord. So in 1970, Dipa Reserve Forest was notified, my lord. And we were within, Jipu village was within, well within this Dipa Reserve Forest, my lord. But suddenly in 2014, my lord, a massive flood occurred, my lord, and washed away completely, washed away this Jipu village. And all our records
Will issue notice, sir?
my lord. And your lordship, this interim observation may be made, my lord, that not to disturb the settlement there, my lord.
You are within the reserve forest.
My lord, I was already there, my lord. In Jipu was also within this same reserve forest, my lord. In fact, reserve forest came after my ancestor dwells there, my lord.
When it was Gogar or Dipu?
My lord,
This
actually,
Gogar
it is Dipa, my lord. Dipa, and I will correct it, my lord. Gogar is a beat area, my lord. Beat forest area, my lord, within Dipa. Gogar is a name of area, beat area, my lord.
Is Dipa?
Yes,
Dipa Reserve Forest.
The Dipa Reserve Forest, my lord. My lord, I will show your lordship one document, my lord. Page 41, my lord. It shows since when I was, my lord.
Yes.
Lordship, the present writ petition is not maintainable because earlier lordship on the same ground lordship, writ petition was filed. That was without liberty.
It's okay. It's a matter of.
But there's a judgment lordship, Honorable Supreme Court said lordship. The principle laid down provided in the Order 23 Rule 1 will be applicable in the writ petition also.
Where is that earlier writ petition? What is the earlier writ petition?
And that this text also has been suppressed also.
My lord, if I am not wrong, my lord, we have not, some writ petition I have annexed here, my lord. Regarding writ petition, we have
Withdrawn.
annexed, no, not withdrawn, my lord. It was
No, it's
under,
fine. It's his name is there. It's your writ petition.
my lord.
You have withdrawn it.
No, my lord,
It's a
It
page
is-
90, the order, while issuing the notice, it still was granted. That order has been annexed. But this withdrawal order is.
my lord, that was regarding eviction, my lord. It was regarding eviction, my lord. That was regarding eviction. We are here for creation of village, my
Where
lord.
is that issuing notice, issuing notice
Page 90, Lordship.
90, 90.
90, Lordship.
Okay.
My lord, Mr. Ratan was there.
It is correct, Lordship, in that writ petition, Lordship, the eviction notice was challenged. Lordship.
My lord, we are not challenging any eviction
But
notice
here
here, my
also
lord.
the indirectly, Lordship, the same issue.
No. Please come to my prayer, my lord. Please come to my prayer.
That is correct, Lordship.
Okay. Heard Mr. Tijamo, learned counsel for the petitioners. By filing this writ petition, the petitioners have prayed for a direction to the responsible authority to issue no objection certificate, particularly Forest Department,
My lord, yes.
Department of Forest, Department of Environment and Forest and Climate Change. Is that name of the department? Anyway, Department of Forest, Environment, Forest, Government Department said to this. For creation of the proposed Jipu Dodi village, a census village within the Deepa Reserve Forest,
Deepa Reserve Forest, my lord.
Forest in the district of Lawal Siang, Arunachal Pradesh. The petitioner claims to be a displaced person of all Jipu village which had all Jipu village situated within the same reserve forest area. Within the said reserve forest area due to flash flood. Please stop. The petitioners also prayed for providing the benefits under the scheduled tribe forest dwellers and the scheduled tribes and other traditional forest dwellers within bracket recognition of forest rights. Bracket Clause Act 2006. Issue notice returnable. 4 weeks. Next para. Since Mr. Estapin Land Council, Land State, Land Senior Government Advocate enters appearance and accepts notice on behalf of all the respondents, no formal notice. Need be served, however, extra copies be furnished to the students. No other private respondent.
No private respondent, my lord.
Next, considering that the petitioners are settled in the proposed Jipu Dodi village within the reserve, Deepa Reserve Forest after being displaced due to flash flood from the old village situated within the said reserve forest
Yes, my lord.
and continues to be
1.5
living,
kilometers away.
living since
only one
Since
2015, my lord.
since 2015.
My lord.
Come on.
It is only 1.5
The
kilometer away from
status-
our old settlement.
The status quo again today shall be maintained till returnable day. As Mr. Estepin, Learned Senior Counsel has raised the issue of maintainability on the ground that the petitioner has withdrawn, has approached this court. And however, they have withdrawn the writ petition without seeking liberty. Come on. Same shall be considered on the next returnable day. We'll see.
Okay, we'll counter.
Status quo. Status quo.
Okay, my lord.
Happy, not happy.
Actually, happy, my lord.
It appears to be to avoid the eviction.
My lord, my lord.
You are seeking a different prayer. I mean,
No, not like that, my lord. I swear, in the name of God, my lord, I swear. Actually, we really want to, genuinely want to stay there because we have no other.
you cannot unless it's a reserve forest.
My lord.
Even the state would not have any right now.
Lordship, admittedly, Lordship,
That's the reason although the land management department has recommended, it cannot be considered. It has to be de-reserved, it has to be de-notified.
My lord,
As it's within
the rule,
the power is what? Under Forest Conservation Act.
anyway, my lord, we will come with the rule.
You
precisely,
need
my lord.
to implement the central government.
Central government. Okay, my lord.
Once it is declared or notified as a reserve forest.
Okay, my lord.
as well.
Lordship,
We'll see
even
about
this
it.
interim order is not required here actually. The prayer short is.
No,
Lordship,
I've seen,
what
they
prayer
are
they have-
apprehending eviction. They really wants to establish the thing. That establishment of village will not be permitted easily.
My lord,
Although the
there is,
land management department has recommended.
There-
It's a notified reserve forest.
my lord, there is provision, my lord. Provision, rule 2006 says, my lord, there is provision for establishment for people like us, my lord. But outsider,
What rule?
Arunachal, this, that we have placed there, my lord.
Lordship, eviction order is there. That is not under challenge, Lordship. The status quo.
We'll see. People are living. Have some
That's
right to.
true, but eviction order is not under challenge here. Lordship.
We're providing, the petitioner shall not, one more line. Since the petitioners are residing within the reserve forest, they shall not, cause any damage
Yes, my lord, yes.
to the environment ecology
Right.
of the forest area.
But the entire Lordship facts is goes against the Lordship Forest Conservation Act
We'll see.
1980 Lordship.
We'll see. I have indicated.
Lord.
Why you are not releasing?
My lord, it seems, my lord, there's a complaint. That's why, my lord, complaint by one woman welfare organization. My lord. I feel it should not be relevant, my lord.
Yes.
My lord, maybe directed, my lord, this concerned DTSC, my lord.
Heard Mr.
Jacob.
So and so learned counsel for the petitioner. And Mr. T. Tangum, learned additional, learned standing counsel, education department. Considering the, no, sorry, as the, considering the nature of the grievance raised in this petition, And as consented by the land council to the parties, this writ petition is heard and disposed of at the motion stage. There is no private respondent.
No
No,
private.
no.
response.
Next, the simple facts of the case are that the petitioner who is serving as trained graduate teacher being appointed on 2012-2015 under the Department of Elementary Education, Government of Arunachal Pradesh. Was serving at Government of GUPS, huh?
GUPS.
Pagia Valley, Sepa, East Coming District. List of pursuant to the rationalization of transfer policy of the state. The petitioner is sought to be transferred from the GUPS. What is this transfer order?
My lord,
Transfer order is
Page
page number
12.
12.
serial number 2 is petitioner.
Page 12.
Yes,
Yes,
Annex 2, page 12.
Serial number 2.
Yes.
yes.
Okay. An order, transfer order was by the order, transfer order dated 29/05/2025 was issued by the Commissioner Education, Government of Arunachal Pradesh, whereby as many as 45,
Yes, ma'am.
Yes.
35,
35, ma'am, 35.
35 primary teachers and TGT teachers have been transferred. List of the including the petition list. The petitioner is transferred from GUPS Pagia Valley to Itanagar at the disposal of the Deputy Director of School Education, ICR Itanagar. List of Please, however, the despite repeated approach, the DDSC, the Deputy Director of School Education, SEPA, has refused to release the petitioner. Any order passed? Refusal to?
Madam, no order
No
has been passed, madam. Only that page 17, madam, it's a complaint from other third party women welfare organization, madam,
Okay.
requesting not to release.
Mr. So-and-so, Mr. So-and-so, land council for the petitioner submits that the respondent authority, particularly the Deputy Director, School Education, SEPA, is coming district, has illegally refused to release the petitioner despite a legal, despite the order despite the order of transfer by the Commissioner of Education. Mr. He submits that the reason for refusal to release the petitioner by the Deputy Director of School Education, East Cameng District, appears to be on the basis of the complaint filed by the Women Welfare Organization, East Cameng District, alleging alleging against the alleging certain alleging serious allegations against the petitioner. Which cannot be a ground to refuse release even after the valid transfer of the competent authority. Therefore, he submits that the DSC so and so may be directed to release the petitioner forthwith. Next paragraph. Mr. Tita Learned Standing Council fairly submits that since the order of transfer of the petitioner is past validity, and in order to rationalize the transfer of the teachers, the Deputy Director of School Education, SEPA, is obligated to release the petitioner. Next one. Having considered the submissions of the council for the parties, in considering that the order of transfer dated 29/05/2025 reflects the transfer and posting of various primary teachers and trained graduate teachers. Well, as many as 35 teachers have been transferred and posted in different places of posting. And the different place of postings, including the petitioner. I am the view that there is no reasonable ground to refuse release of the petitioner, as the transfer order has been passed by the issued by the Commissioner of Education, Government of Arunachal Pradesh. Mr. If at all any allegation is leveled against the petitioner, the appropriate course of action, there would be a appropriate course of action which may be initiated in as per the law, under the law. But in any case, the mere complaint of alleging, even if a serious allegations, cannot be ground to refuse release of the petitioner. I'm constrained to direct the responding Number 3, respondent number 3, I, Deputy Director, School Education, to release the petitioner from the post, from GUPS,
Yes, my lord.
Pania Valley.
Government Upper Primary School, Pagia.
Huh?
Government Upper Primary School,
Yes,
Pagia.
GUPS, Pania
Yes,
Valley.
Yes.
Bhagia Valley.
Is coming district. SEPA to enable her to join in his new place of posting. District. However, the court refrains from making any comments with regard to the allegation level against the petition by the, what is women welfare? Women welfare organization, Islamic District SEPA. Is the is this allegation is the law will take its own course on such allegation.
Declare.
All right.
Read petition disposed of, huh?
Wait, here.
Yes.
Petitioner here, my lord, is putting to challenge the termination order of the petitioner, my lord. The stigmatic termination order. There were no notice, nothing was given to me. The termination order is at page 21.
Yes.
Whereas it has been reported by Superintendent of Police, Karadati District on 5th February to the effect that a case has been registered against one such and such the petitioner under Palin PSK slide number such and such under section such and such. And the accused remains such and such. Whereas the contract therefore next exercise of such and such, this provision is wrong. For immediate termination of above mentioned accused is hereby conveyed. It's a stigmatic order, my lord. In the meantime, my lord, the petitioner has been acquitted of all charges.
So your basis is on this now.
Not on this, I am just providing, my lord. This is what has happened. So this was an stigmatic order without any notice to me, my lord. I am on that ground. And consequently, this has also happened.
You bring on record, we'll see. You bring on record this.
The affidavit.
Otherwise, what is your stance?
My lord.
Otherwise, in the affidavit also they have said that since notice was not given, we can do that again.
My lord, my lord, the respectful submission in this case, my lord, he was contractual employees, my lord. Under contractual employees, my lord, before termination, because he was already arrested and he was remanded for 14 days, my lord. There's a in case of regular employees, my lord, 48-hour detention is deemed suspension, automatically suspended, my lord. But in case of contractual employees, my lord, there's no provision of suspension and all. But in that case, my lord, my respectful submission, if the contractual period, if it is not renewed, my lord, it's automatically, my lord.
Not renewed is something different. It's then terminated because of the arrest, because of this case.
My lord, as per the ground, my lord,
if you have the provision for suspension, but at least notice ought to have been given.
Yes, my lord.
There's
But
a-
regarding, they have quoted, they have mentioned certain provision, that is civil. Central
That has been
Civil
wrongly
Service
mentioned.
Temporary rules 1960. Although it's wrongly quoted, my lord. This rule is not applicable in case of contractual employment. It's been wrongly quoted, my lord.
It goes in the.
My lord, in case in that case, my lord,
Your
wrongly-
power, the power you have derived
My lord,
is non-existent.
not if, my lord, this is wrong quoting of the provision only, by respect.
Otherwise what? On which provision?
Otherwise, only on the basis of this, my lord, there's a criminal case against, he has been arrested, my lord.
What is the contextual, what is the agreement says, what is any agreement to that effect?
No, madam. There is a on contractual employees also, there is a judgment, direct judgment very
No, that's why, was there any agreement saying that if
No.
the petitioner found to be involved in
My lord,
criminal case or arrested,
my
contractual
lord,
service will
that
be
is
terminated.
not only what is
There
required.
must be some agreement,
Yes, there is.
or the
The agreement is for valid for 1 year only, that is to be extended year to year, madam.
yes, but then if it gets automatically states, I mean, terminated on the expiry of 1 year, that is another
That is
thing. You have the basis is for arrest because of the arrest or registration of the case against the petitioner, and the power you have,
My lord,
you yourself is saying that it is not the,
in my respect.
you don't have the power under this provision.
My lord, this, it has been wrongly quoted, my lord. My respectful submission, how they have understood this, but so far the contractual employees concerned, it does not comes under this temporary service rules, my lord. It does not. And under the requirement,
It's a non-as.
yes, my lord, under this provision, there's a requirement like before termination, notice period, and in lieu of notice period,
And my lord,
amount has to be.
notice one thing, in the affidavit they have said that the humble dependent denies the Eastern Marine such and such. At paragraph 10, it is submitted that if there is left any due process to be followed, the department will complete it as may be directed by reasonable court. But it is stated that the petitioner being involved in a serious act, criminal act, it is not desirable for department to keep in service. So if there is a lapse, my lord, they would like to complete it. So that my lord liberty can be granted.
That-
It's on their affidavit.
We want to provide more than this. We bring in record.
Well,
That would be better, my lord.
What they will do?
My lord,
They will issue a notice
Yes.
because of this, because if you are found not to be fit to be continued, terminate.
Hmm.
It just, we just, let
now,
us examine and
Yes.
look into deeper on it.
now pursuant to the judgment, that will not be possible also.
Hmm?
Pursuant to the judgment of the criminal court, even
Hmm.
the reissue notice.
That's why you want you to bring it. We can examine little deeper on the
yes,
issue.
my lord.
Okay.
Just to giving them, I mean, license to issue a notice and
That is
terminate
also there,
again.
yes.
Okay.
Okay, I will file the full
Yes.
judgment also.
And Mr. Deepang, Land Council for the petition, and Mr. Land Standing Council for Education Department. Let this matter be listed after 3 weeks so as to enable Mr. Pangi, Land Council for the petitioner to bring on record the order dated 13/12/2024, whereby the Landes CGM 0 has acquitted the petitioner from honorably acquitted the, it is honorably acquittal.
Yes,
or what?
my lord. If it appears there was no evidence,
And
false case.
been acquitted from the criminal charges, and which was the basis for criminal charges in GR case number 63 of 2022, which was the basis for termination of the petitioner from the contractual service. To what I'm saying, to bring on record. By way of affidavit, huh? Bring on record by way of affidavit of the order that is filed. Yes.
My lord, this petitioner is the Anganwadi worker. Since from last 1998 to since from 2016, my lord. Yes,
What?
yes, my lord. Thereafter he was up there after 2017, my lord, he was without any so cause notice, my lord. So cause notice terminated from her post, my lord. Anganwadi worker.
Yes.
Well, my lord, as per my lord senior instruction, my lord, as per my senior instruction, he was petitioner has filed rejoined, my lord, against the respondent number one. So my sometime maybe
When the private, who is the private respondent?
Yes, there is, Your Lordship.
Any service is complete.
Judge, Your Lordship. I haven't checked it, Your Lordship. I haven't checked it, Your Lordship.
It has been duly served. What is your strength?
Your Lordship, the petitioner was absent without any, without giving any information to the concerned officer, Your Lordship.
Is it a regular service or what?
No, Your Lordship, it's temporary, Your Lordship. Temporary, Your Lordship.
What is your appointment?
Page 13 of our affidavit, Your Lordship. Annexure 1.
Otimoyo.
Yes, Your Lordship.
Are you a helper or worker?
yes, my lord.
Helper. Anganwadi helper or worker?
Worker, my lord.
Worker, Your Lordship.
Worker.
Worker.
Yes, my lord.
See, the appointment of this respondent number 4, or who? Respondent number
4 years.
4 is of Siko Anganwadi Center. And the appointment of petitioner is of for Adipasi. Different center. Any termination order?
No, Your Lordship, as per our affidavit, no.
See, look at this appointment.
Yes, Your Lordship.
On the termination of Anganwadi worker, Tilak Darin of Adipasi, right?
Yes, Your Lordship.
Petitioner has been appointed. On page 31, it's of Siko village, Siko Anganwadi center. It appears to be different. Different Anganwadi center. And there is no termination of the petitioner, termination order.
Then, Your Lordship, I may be allowed some time to take whether the termination order is there or not, Your Lordship.
Heard Mr. So-and-so, learn counsel for the petitioner. It is seen that the appointment of petitioner as Anganwadi worker is in respect of Adipasi Anganwadi Center. Whereas the appointment in respect of respondent number 4 is of Siko Anganwadi Center, which
Your
appears
Lordship,
to
it
be-
says Siko under bracket Adipasi.
it's written.
Yes, in our affidavit, Your Lordship, page number 40, Your Lordship.
40.
Yes, Your Lordship. Miss Aruna Dai of Siko under bracket Adipasi village is hereby appointed as Anganwadi worker.
40.
40 years, Your Lordship. But Your Lordship,
Where it is?
in our affidavit, Your Lordship,
Yes,
page number 40, Your Lordship,
page 40 years.
dated 1st February 2017, Your Lordship.
Huh?
It's a typed copy, Your Lordship.
Of Siko. Okay.
Yes. Siko under bracket Adipasi. It's written like that, Your Lordship.
That means Siko and Adipasi are same Anganwadi
It
center.
seems so, Your Lordship. But Your Lordship, however, I may be granted some time to clarify this one also. Your Lordship.
What is it? Adivasi nahi. This is Siko Anganwadi Center. Which is within brackets shown as Siko within bracket Adipasi. Bracket number. Mr. Which appears to be a different village, different Anganwadi center, huh? Two different Anganwadi centers. Mr. Boyderam, London, State Council pressed for and granted 2 weeks time to obtain instruction. And as to clarify whether the Siko Anganwadi Center and Adi Anganwadi Center are one or a different Anganwadi center. This after 2 weeks.
Obliged.
Mayor, my lord.
Yes.
Your Honor, that the petitioner has his own plot of land situated in Chimpu, Gopuyor, and residing there more than 21 years, Your Honor, and some other peoples are also residing there, Your Honor. And earlier, Your Honor, there is a link road, that float of that sector, Your Honor. The colony member, they are also used that link road by Pudvat, Your Honor.
Your Ila Jyoti Mije,
Yes, I'm.
what's
respondent
your
of
name?
five.
What is your name? Ila
Yes,
Jyoti
Mije.
Mije.
Yes. I'm representing both respondent 4 and 5.
Which five?
This Ilajuti Mijay is 5.
Yes.
Yes, Your Honor, I being consent by respondent 5, Your Honor, I took earth cutting out there, Your Honor, for motorable road, Your Honor. So there is no illegal any earth cutting there, Your Honor, because all colony members use this that link road, Your Honor. And Your Honor, I have no any instruction from senior counsel to hear for hearing this matter, Your Honor. Moreover, Your Honor, I have no any instruction from my senior counsel, Mr. B. Arun, to hear this matter, Your Honor. This is serious matter, Your Honor. So
Serious matter.
yes, Your Honor.
What serious? You
It's,
you have admitted that the land belonged to the respondents.
yes, Your Honor, but it's for
Minu Dodum. Who is Minu Dodum?
Whom this respondent of 5 gifted the land. Now she is occupying.
Approach road, you can
No.
provide. What's the,
No, but,
how can you stop?
yes, Your Honor. There is no alternate any road, Your
I
Honor.
don't want to argue with this one because let the council come. We'll just.
She is made out. She wants the approach road. Will provide. You allow approach road. 4 meters. Yes.
This is a legally allotted plot of land. But this matter is so sad. The respondent, if I have to exhume his husband's body and bury it at Pasighar because of the petition.
Then it become very serious.
Sacrilege of the even grave one.
I'm a so-and-so learned counsel, the petitioner who submits that. She may be, the matter may be adjourned for 2 weeks as her senior who would be arguing the matter has some personal difficulty. Please, the prayer not being objected to by learned counsel for the respondents, Mr. MSS K. Wang, London State Council, and Mr. Peter, London Council, respondent 4 and 5, 3 and 4.
4 and 5.
4 and 5, huh? That date may be listed after 2 weeks.
Lordship, just I want to pray, can it be fixed on 4th August?
Why? Why fix matters? Fix.
Others,
On age agreed to by. Then in that case, 4 weeks. Mr. Age agreed to by, learn council for the first list on 4th of August. 4th of August. If your senior is, if he cannot appear, on next time, you take a permission to argue.
My lordship,
Hmm.
my lord, my
Use
lord,
the mic.
my lord, actually, I would have take examined this matter because
You have not granted.
yeah,
I have not granted. You are good the matter. What is the matter?
actually, Your Honor,
What's the brief?
yeah, the fact of the story is that petitioner is one of community of Semung community. So actually, Semung community were built some statue and kitchens that they were built for a purpose of religious, but unfortunately they were cut by some fire. So that's why the petitioner have FR root against of Semung village. But there was no proper investigations. That's why so application is filed for re-investigation.
Re-investigation.
Re-investigations.
Can you allow this?
Yeah. Oh, sorry.
Even I got confused.
Sorry. My lord, sorry.
I am for the petitioner, my lord.
Hmm. So what do you want?
Your Lordship, I was seeking adjournment on this morning for respondent number 4 and 5.
Who are you? Hmm?
Your Lordship, we'll take the proper instruction from the senior standing council, Your Lordship.
Hmm?
So 2-3 weeks time may be given, Your Lordship.
Why?
Council is out of session, Your Lordship, due to its personal difficulties.
What personal difficulty? Yes, sir. This is who is for the petitioner?
I am, my lord.
Have you gone through the brief?
My lord, actually, yesterday, my lord, council for the respondent number 4 and 5 inform us that they are not going to hear this matter.
I just wanted to know. Okay, we'll adjourn it. What is the matter?
The matter is, my lord, related to the eviction order.
Ah,
passed by the Deputy Commissioner, Capital Complex, my lord.
Against you.
Yes, my lord.
So what is your right over the land?
My lord, that I have not been instructed.
You are there? Yes, you are good. What is your right over the land?
My lord, as my lord, my junior said that since we have been informed, therefore, my lord, we are not ready to dispose of the matter. But whatsoever so far the question of the lordship is concerned, that I have not claimed the land, but this is the community land where, my lord, we have adopted. My lord, in the question is particularly for the, my lord, establishment of the, my lord, primary health center. And accordingly, my lord, with the work order, my lord, that was started. And investigation was also made. And accordingly, my lord, the concerned officer also, my lord, visited the spot, and thereby, on the recommendation of the office concerned, my lord, work was started. But in the meantime, my lord, this private respondent, particularly 4 and 5, has dropped the complaint against me, my lord, that illegal construction is going on there, man. So without hearing to me, without giving an opportunity to me, my lord, this impugn order has been passed by the Deputy Commissioner, man. So I am here before the lordship against the
You read the
order
impute
passed
order,
by the
page
Deputy
51.
Commissioner.
Page 51.
My lord, 51 of
Writ petition.
my lord. This, I am in the serial number 1, my lord, Pagum Yamna. I am 2, my lord, Pagum Tabu. Whereas the Deputy
You first
Commissioner,
decide whether you are 1 or 2.
I am 2, my lord,
Yeah, you are the contractor.
my lord.
Legally awarded contractor.
So where, my lord, it has said, whereas the Deputy Commissioner Capital Complex by number such and such dated Itanagar, 19 September 2023, order ESC State Capital to carry out eviction drive against the construction at the lower mob to Itanagar on 20 September 2023. Whereas
You have not opened your brief.
my lord,
3 of you are the petitioners here. Pakyum Yana, Pakyum Tabu, Tamsi Tajik. Yes, this is for construction PHC.
Yes, for a primary health center. Now, my lord, this land belongs to a government. Now, petitioner number 1, my lord, that is Pakum Yama. She is a corporator, my lord, ward number 9. The present petitioner 2 is a contractor, my lord. The number 3 is, my lord, he's also my ward member, my lord. Now, the ward member of the mob 2, my lord, they lodge a complaint because I have seen that place. It will be around this area, my lord. That is the only left out children playing ground in Capital Complex. And in case of my lord, occasion, my lord, the puja festival are held there, my lord. Now, without knowing the ground reality, my lord, this area was, my lord, given sort of permission, my lord, for the primary health construction. When company was lodged to the Deputy Commissioner, my lord. Now, Deputy Commissioner being the chairman of the Urban Development, my lord, board, my lord. Then it was found that, my lord, that land is, my lord, is not visible. It's not, my lord, vacant land. It cannot be termed as a vacant land. It's a children garden, my lord, playing ground, my lord. So in that lieu, my lord, then the work was stopped, my lord. So I guess then, my lord, they had before the lordship, my lord.
Sure. It's yet to be decided.
Yes, my lord.
What is to be done?
That if that is to be given, my lord, there will be no children playing ground. There will be no place for holding a festival, my lord.
Who are they?
My lord, they're also, my lord, member of my lord, IMC, my lord. They're also ward member, my lord.
What is
They lodge complaint, my lord.
you have made a complaint.
Yes, my lord. They lodge.
You are in favor of children park. I mean, children play. All right. And you are for PHA,
my lord.
construction PHA.
PHA, my lord.
Yes, my lord.
My lord,
I
in
think
this
you,
case,
it is 2023, you obtain instruction,
my lord,
might have decided now. But
as
still-
on that, my lord, there is no any construction because of this imping water, my lord.
There is no
Yes,
construction.
my lord. So best, my lord, result could be, my lord, the petitioner, my lord, they'll cooperate with the, my lord, district administration to find out the alternative plot, my lord. Otherwise, in and around in the capital complex, that is only children playing in the ground were left out, my lord. The concepts are,
So why you needed time?
Council is not present, your lordship.
Who is the?
yeah. That's all.
Anyway. As prayed for by. No, at the request of Mr. So-and-so, learned counsel for the, learned counsel appearing on behalf of Mr. T. Rigia, learned counsel for respondent number 4 and 5. And as agreed to by learned counsel for the, Mr. C. Modi and for petitioner and Mr. Arich Nabu learned additional advocate general for this state. Let this matter be listed.
After summer break, my lord.
After 4 weeks.
Oh. Sir, we के लिए चला गया.
Well. Affidavit. Will file affidavit.
We have filed.
Who has not filed? 1, 2, and 3.
Respondent 5 and 6 have filed.
Who is 1, 2, and 3? Commissioner,
Commissioner, that
Director
Five.
General.
Chief Secretary, Commissioner,
Hmm.
that, well, 5 and 6,
This will cover.
this will cover.
Yes.
Your Honor, actually, I have already told you that we have come here for especially for arguments. So we don't know any idea about this matter.
Are you a lawyer or are you a?
So actually, recently my friend is engaged to him, engaged to me. So
Hmm.
that's why we have not enough time to study about this old facts. Actually, this brief story is that petitioner is a community of Memba Kamba community. So actually, they were Memba Kamba community. They were built some building and kitchen statue, but they all are cut by fire, some miscarriage. So they were a petitioner
What by fire?
a statue or kitchen. Yeah. So that's why the petitioner FR looks under section FR looks regarding of Kamba village against Kamba village. So there was no proper investigation. So that's why this application is filed for a re-investigation.
Why, how you can say that there was no proper investigation?
Respondent says
Hmm.
actually we have already a FR that they were investigation, but that investigation result is not properly. That's why we have filed these applications. That's only.
So,
So matter will be released after 3 weeks. My senior is very indicated.
yes, only prior of so and so, council for the.
And I have already concerned the opposite party.
And the prayer not being objected to by. Mr. And not to learn a additional book. El Kurdu. 4, respondent number 4. For respondents, list after 4. What is your stand there?
Well, we have conducted the investigation.
Fair-
There was
fair-
a progress
fairly.
petition.
Fairly.
Yes, we have fairly investigated.
Okay.
What's up, like?
Absolutely. Malad, may I pray that Malad, 3 weeks time may be granted. In the meantime, Malad, I'll file additional affidavit, Malad.
Additional affidavit or reply?
I'm sorry, Malad, affidavit in reply to the affidavit in opposition filed by the government.
Further 3 weeks time is granted to learn counsel for Mr. M. Kato for filing affidavit in reply as a last chance.
Malad. Definitely.
For last chance or second last?
It's okay.
Forget it. Not last chance deleted.
Deeply.
Please.
Yes.
Malad. Malad, before come to the facts of the case, so far pleading, actions of pleading is concerned. Private respondent number 4 is yet to file.
Who is
Respondent-
private respondent number 4?
Private respondent number 4 is the private,
Huh?
Mondal of the BJP who has terminated me. The matter before the lordship is pertaining to the termination against the termination order where I have been terminated from the primary membership of the BJP for 6 years, Malad.
So how the writ petition is maintainable? You file a title suit, civil suit.
Malad, let the matter become after vacation. Malad.
No. It's a termination by the political party.
Malad.
You file a civil suit, that's all. How do we go into it? Not Mr.
Malad, if
It's
lordship is
disqualification by the deputy commissioner.
Deputy Commissioner.
Yes,
Then-
not only termination by political party.
in pursuant to the termination, this disqualification has been passed by the deputy commissioner. Therefore, the impugned order,
Disqualification is
As
impugned
Gram
order-
Panchayat, GPM.
DPM.
Therefore, the main impugned before the lordship is against the.
No, in that case, we are
Disqualification.
challenging the disqualification.
Yes.
The basis may be the expulsion from the party.
Exactly, lordship.
Right.
What I am challenging before the lordship is.
Yes. The
Yes.
basis of disqualification is
Disqualification.
termination from the party.
Party.
Vishwanathan.
Yes, Malad.
I think law is well settled now.
Disqualification order has been passed by the deputy commissioner.
You are challenging that.
Yes,
Then why did you say that? You said
my lord, actually, my lord.
you are on the way to submit that.
Exactly, my lord. Exactly, my lord. I am trying to, my lord, display that the respondent number 4, who has terminated and in continuation to that, this qualification has.
Let us see the law. Vishwanathan and other. Was there any, what about the larger bench?
Malad, larger bench.
The Amar Singh.
Amar Singh, Malad, Amar Singh, that larger bench, that was not decided, Malad.
Still pending.
No, Malad, that was not left open, Malad.
Left open.
Yes.
No, reference it was sent back.
Yes. Second, Amar Singh, that it was just observed that in the appropriate case, this will be decided.
There's an order while passing interim order, we have recorded all this thing by division bench in some relative
Yes.
matters.
That
And-
matter, disqualification matter of Yachuli,
The
ZPM,
second to Supreme Court also.
Supreme Court,
Then what happened?
that it is pending.
Spending. Finally, writ petition disposed of.
The writ
Writ
petition
appeal.
was, writ appeal was dismissed it was appealed before the Supreme Court. Then there is a stay, and this because it would be for the Supreme Court to decide that issue.
But
What was left open in the Amar Singh case,
as it stands,
not decided, not yet.
that has been stayed. Division bench order has been stayed.
Yes,
Judgment is.
that has been stayed.
Have you come across that?
No.
It will have it will help all of us find out all those judgments. You take it from him. The detail of this writ appeal, Vishwanathan, Amar Singh. There's a stay.
Yes, in
Yes.
this, there is a stay.
That's the reason. Okay. On the prayer of Mr. C. Modi, learned counsel for the petitioner, and prayer not being objected to by Mr. So and so, and not learned additions, Advocate General. List the matter after 4 weeks.
And the interim order passed earlier.
Continue.
Continue. All black.
Number 15.
Your Lordship, we.
Yes, madam, yesterday's judgment,
Yes,
that is 2020-19,
2020, volume 9.
9.
Yes.
The Hare Krishna.
Hari
Krishna.
Hare Krishna Mandir Trust,
Paragraph.
paragraph 96 onwards, 96, 97 and the rest.
98.
Yes. Page number 356,
343.
365, now I forgot. But
I think they found it.
Yes.
Yes. Yes, it's a,
May I, Your Lordship?
yes.
Your Lordship, we are yet to receive the Paravas comment from
Why this is listed today?
this is for orders.
orders, Your Lordship.
For affidavit.
Yes, Your Lordship.
Okay. Heard MS in the learned counsel for the petitioners. Mr. Wider of London Spring Council is granted for the 3 weeks times to file affidavit in office. List after 3 weeks.
There's an interim order also.
Huh?
Interim order.
Interim order passed, I'll still continue.
Obliged, Your Lordship.
16.
Yes.
Do office note dated 26/6/2025. 22 service report in respect of respondent number
I
4.
would service report.
May I, Madam? In this case, my lord, I have taken steps on respondent number 4 on 3 occasions. Therefore, my lord, I pray that the resumption of service may be drawn.
We'll wait for some time. R.L. Tungan, Land Council for the Petition, and Mr. Wider of Land Council, Registered Council for Respondents. I would service report in respect of respondent number 4.
4.
Yes.
After 4 weeks.
Yes. Yes. Closed. Closed.
This case, my lord,
Closed.
otherwise,
Has become infructuous, you file, you may challenge. You can leave.
because the issue, my lord, at least this could have been waited for some time.
Huh?
This could have been waited for some time.
You challenge that, we'll provide you. See, give
Yes.
it. At least the contempt is closed. There's no contempt.
Intentfully, this is to close the contempt only. Intentfully, this is to close the contempt only.
Huh?
Because this so-called notice, when it was issued, we put to challenge
that so cause notice in this writ petition.
Huh.
And
Then
during the pendency, it was issued.
was there
There was no
any,
stay.
any bar?
No,
No,
Any bar to proceed with?
no, man.
no,
Then?
actually, there was no stay.
Then.
So in that case.
Yeah, why don't you unnecessary, you challenge that, whatever,
No, no,
on
let
its
it be-
own merit?
Let it, my lord, remain.
No, we're closing it. You are challenging the so cause notice that has gone.
Will
You are
upgrade the.
challenging the writ petition is what?
The so-called notice.
So cause notice.
Then?
And that so cause notice culminated to.
Yes,
Fresh cause of action.
there's no order, there's no bar to proceed with.
In fact, the so-called
You
notice
could
was
have
on the basis of the
obtained,
liberty granted by the division
you
bench.
could have obtained the interim order. It's for you, the litigants only were suggesting. Go to challenge all those things, and at the same time, you may have raised that also, the initiation of the so cause, if there may be permissible under the law. Right.
Soko was in terms of liberty granted by the division, honorable division bench.
Huh.
Well,
So cause as per the,
In the liberty granted by the honorable division bench. Yes.
so you may decide, challenge that all only.
It will have to be challenged now.
Because, as you said, the Sokoji was issued, right? In terms of the liberty granted by the division bench.
my lord.
So you have put to challenge. There's no bar and there's no restraint order or whatever. They have proceeded, culminated in the final.
It was more or
order.
less, my lord, contention will be same,
Whatever,
the writ petition, which is.
whatever. But you have to challenge that. Are you not interested to have a different kind of, fresh kind of petition?
Petition definitely will be challenging this.
It's part of the profession. We have to accept it, right? We'll just say in process.
Yes.
Infractions.
We'll say this contempt, it's duly complied with, right?
No, man. Contempt not complied.
No. What is the
For-
contempt?
Contempt is for non-compliance of the judgment passed by the single judge.
That has not been interfered by the division bench.
That has not been interfered with, but liberty was granted.
Huh.
So in terms of the liberty consequence, action has come now.
Huh.
Contempt has to be closed, and the writ petition has also become infructuous.
The decision of the single bench, my lord.
What
There are
was
That was
subsequent,
not interfered with the
Ah.
decision.
Hmm.
And therefore, we have filed a contempt petition.
Hmm.
Of course, liberty it was given to the bank to proceed with the de novo press D. So therefore, my lord.
so there are,
this
So
contempt-
even if it's not interpreted, when the liberty is granted,
Yes.
in view of the order projects, it's as good as
Yes.
compliance.
yes.
Two things. May not have interfered with the single bench order, but then if liberty is granted, an option is given by the division bench, and that option has been availed by the respondents, what more?
Ultimately,
We'll just say, heard Mr. K. Tamalan, counsel for the petitioner, in writ petition, item. Not heard, Mr. K. Tamalan, counsel for the petitioner. No, it is submitted at the bar. Mr. K. Tamalan, counsel for the petitioner, and Mr. Deepang, counsel for the respondents, have submitted that in view of the order that it's so and so. You
for
just give
2025.
the, 1/4
4 April 2025. 4
4
April 2025.
4 2025, passed by the
passed by the disciplining authority, my lord.
discipline authority,
Arunachal Pradesh Rural Bank.
Arunachal Pradesh Rural Bank.
Yes.
The writ petition has become infructuous, according to writ petition stands closed on infructuous, as in infructuous, in contempt. Contempt also, in view of the order so and so, Then will you write, heard Mr. K. Tama before that, huh? And Mr. G. Pagi, learned counsel for the petitioner, and Mr. G. Pagi for learned counsel for Alice contempt, huh? Contempt. In view of the order, so and so, same order, huh? Passed by so and so, the contempt petition stands closed and disposed of. We'll just say.
Obliged.
If you are not happy with the compliance.
Highly honored.
Yes. Yes.
My lord.
Who is the respondent number 4? Heard MS D. Rilu, counsel for the petitioner.
Petition.
And Mr. Surens, Tita Learned standing counsel for
Education Department,
Education
respondent 1, 2,
Department.
3, my lord.
award service report in respect of respondent up list after 4 weeks.
May I please, Lords. As for the last order, ma'am. Respondent number 5 is taken to time to file their affidavit, ma'am.
Yes.
My lord, we will not be filing an affidavit, madam. My lord, this matter is in fact become infectious. My lord. This is a tender matters related to supply of items in the school, man. Those items have been supplied. I have received bill, everything, my lord. The how the tender,
What can we do?
it's become infectious, man.
My lord, the
I don't know.
issue in this writ petition is not regarding, my lord, whether they have supplied the material or not. The issue is regarding, my lord, whether, my lord, if the L1 withdraws its bid after it has been awarded, my lord. And then guess what will
We'll decide that in the appropriate proceeding. We'll keep
Yes,
it
ma'am.
open.
My
Close it. All right.
my lord, that can be decided in this case
We'll
also.
say, no, we'll say that that will be economic discussion. What relief you will be getting?
My lord, if, my lord,
What relief can you be granted?
my lord,
If I decide that
my
in
humble
your
submission,
favor, in your favor also.
yes, my lord, in my humble submission, don't
According to you, if L1
withdraws his bid.
withdraws his bid,
My lord,
the
fresh tender will be.
L2 should be given.
Yes, ma'am.
Whatever, why he has been given? He's not L2.
He's L2,
Then
but it shouldn't be, my lord, as per the.
who are you? Who are you? Are you L3?
No, no, so I have participated in tender, ma'am.
Your tender was rejected.
Yes, my tender was
So
rejected.
you are not challenging that.
I'm not challenging that, but my lord, as per the, my lord, procedure, my lord, it should be retender, ma'am. As per the procedure, as per the, my lord, this manual for goods act 2022, my lord, it should be, my lord,
Retender.
retender.
No second L2 could have been,
Yes.
should be,
Awarded.
L2 should be awarded.
Yes,
It does once the L2, L1 withdraws,
yes,
then it will be fresh tender.
yes.
My lord,
So we'll see it in the next order. Then today,
it will
if he has already executed everything,
pay- payment,
what
everything
relief?
has to receive.
what relief? We cannot tell them to go for retender.
But, my lord,
We'll say, will the issue will be kept open for determination in appropriate cases.
no, in my humble submission, my lord, if lordship finds, but
That he can.
there is
go to-
illegality in awarding the
case in
tender
civil
to
court,
L2, my lord.
Ah.
My lord has plenary power to pass an order
Hmm.
if it finds that the award is illegal. ma'am. Though, my lord, my
Supply of what?
My
supply
lord,
of
supply of
kits.
school items, man.
Huh?
School
kits.
items,
2 items.
school items.
School items,
Yes.
include, like,
My lord, listed there, man.
My lord, 6,300, I think 6,337 kits are there, my lord.
Or
My
different
lord,
kits, my
that's
lord.
full of
kits.
Study kits.
okay.
My lord, is this their verbal submission only?
Okay, heard Mr. S. H. Lampu, learned counsel for the petitioner, Mr. You have filed the affidavit. Okay,
I'll go with the government.
what is your stand? Sorry, you are not ready. Mr. Peter, learned counsel for the petitioner, and respondent number 5, submits that he would not be filing affidavit. Therefore, please stop. The state respondents has already filed their affidavit. This for admission after 2 weeks. I wanted to dispose it of, but then because even if we all your it was not properly done, awarded, even then no relief can be granted now.
That relief cannot be.
We
accessible
cannot
to-
tell them to once it has been executed. Can we say that go for a fresh tender?
Of course, but my
At best, we'll say that in future, be careful, go with this law.
Purely academic discussion,
That
my
will
lord.
be-
my lord has ample power.
We'll see.
As any of them.
Anyway, we'll see, we'll see.
Obliged.
Yes, sir.
Yes, my lord. This is regarding rejection of my application for appointment as
Why this is listed today?
it is listed in order
Service
for.
completed.
Yes,
You are for?
and for the respondent number one, on behalf of the ACI, your lordship.
Huh?
Respondent number one, your lordship.
On behalf of?
The ACI, Mr. M. Kato.
Rejection of your what?
My application, my lord, only on,
For application for what?
for my lord, appointment. as-
Retail outlet.
Yes,
Service complete.
service completed.
And pleadings also.
Please no, the respondent company is not representing.
You are for the company.
No, this
No,
is
yes.
for the union.
Who is for the company?
They are not represented.
Okay. I heard Mr. D come to counsel for the petitioner. And Mr.
K. Terry.
K. Terry
Yes, your lordship.
for respondent number
1, your lordship.
on behalf of
The ACI, Mr. M. Kato.
DSGY, Mr. M. Kapoor. All the wakalatnama is shown to have the power, although the power have shown to has shown to have filed on representing the other response, non-appeals for today, non-appeals for them today. Next list after 4 weeks. In the meantime, respondents may file their respective affidavits. Yes. 4 weeks.
My lord, otherwise, my lord, my representation is pending, my lord. And till today, my.
Tendency of the bar, the writ petition shall not be barred to dispose of the representation filed by petitioner on which, when did you file?
My lord,
What is the date of your representation?
my representation, my lord, it was filed on my lord. The 15/6/2024.
15/6/20. Page
Number 54 to 55.
54. Reply against your letter. Huh?
Yes, my lord.
It's not 15, 14/6. 14/6/2024. No, it's too late. 2024.
Yes, my lord. My lord, but still the allotment has not been done, my lord.
There is
Although
they stay.
there is not stay, but the company has not allotted.
Okay, 14/6/2020. Representation, huh?
My lord, this is regarding, my lord.
Disqualification proceedings.
Yes, my lord. And my lord,
Steps not taken.
my lord, we have taken the step, my lord.
No.
No maintenance.
It's not taken. Steps for service of notice upon the private respondent has not yet taken. Office note dated 26/06/2025 indicates that the yes,
My lord, and allowed officer, my lord, Mr. P. D. Nair, my lord, he is appearing in all these matter, my lord.
the office will go by.
And although I have not checked the
Just
record,
reflects that the petitioner has not taken steps for service of notice upon the private respondent despite anyway, till date since 22/01/2025. On the prayer of Mr. D. Kamdukulan, counsel for the petitioner. Petitioners, or petitioner only, one.
petitioners, my lord, there are
Petitioners.
altogether 8 petitioners.
Further, 2 days time is, 4 days time is granted to take fresh steps. As a last chance,
My lord,
to take is not fresh steps, huh? As a last chance. You have, there are three office notes,
my lord, I'll take
three
this.
consecutive. Okay, sir. Make it fast. Yes,
Well, in this case, we are filing rejoinder to the affidavit
today. You have filed.
Not yet filed.
The last occasion also you have sought for. Huh? Second time.
Second time, one.
And the prayer of Mr. H. Tama, learned counsel, K. Tama, learned counsel for the petition. List this matter after 4 weeks in the so as to enable him to file affidavit in reply. Mr. N. Ratan, learned additional Advocate General is present. Yes.
Interim may be continued.
Interim order passed earlier shall continue. What is the matter?
Transfer.
Ibu Tanah. Okay.
Highly obliged.
We have filed our affidavit, Your Lordship.
Yes. There is no private respondent.
There is, Your Lordship.
Your Lordship, respondent number 1, I think they are yet to file their affidavit.
Hmm?
Respondent number 1.
Who is respondent number 1?
Secretary Panchayati Raj Department, Your Lordship.
Private respondent is there. Service complete.
We have
You have filed on behalf of whom? Respondent number 2.
Yes, Your Lordship.
Whatever the service. Or Mr. So-and-so, non-counsel for the petition.
I'm submitting the.
May I please?
I understand they are not ready.
Lordship, we have not completed the written argument. So on next set,
What is there actually? Whatever you have submitted, what you have pleaded, you have to bring on, I mean, just
yes,
make it
Lordship, I highly apologize.
in the, anyway,
I will submit mine.
it's your application, no?
Yes, mine.
Heard Mr. Deepang Land Council for the applicant of election petition, respond number 1. Today speaks for filing of a submission of written note. Written note oblique argument. Mr. You file your you submit it.
Yes, mine is ready.
Mr. Pangil Land Council has submitted his written argument. Mr.
Tiga, Lordship.
Tiga, Land Council appearing on behalf of Mr. A. Tata.
Yes, Lord.
Land Council for the opposite party of the election minister
May Lordship.
has prayed for.
Lordship on next Tuesday.
Huh?
Next Tuesday, Lordship.
Prays for listing of the matter for submission of written argument after a week.
No, Lordship, next.
After a week.
Yes.
In view of, let this matter be listed. We'll make it Friday.
Next
We'll
Friday.
make it Friday, 4th.
Lordship, can it be on Lordship 1?
Huh?
1. Since Lordship, there is a fixed matter on 4th. So if Lordship.
Okay. 10100620 0720.
Yes. Deeply obliged.
Lordship may kindly pass over the matter for time being.
What's the rule allow the fight it out?
Some negligence on the part of
It's all right. We'll allow.
I'll show you.
It's okay. We'll allow this. You fight out on merit in the appeal. What's there?
I have filed an rejoinder today
Ah.
just to show
Ah.
that from 22nd, it is an admitted fact that
Ah.
from 22nd of July 2024,
There was
they
no-
have done nothing on and only on 14th of
You
November.
fight out in the appeal. What's there?
But this, the Supreme Court also held that this should not be condoned. Such.
Okay. After some time. After
Okay.
some time.
Obvious.
May I please, Your Honor? When I had mentioned this matter yesterday for listing it today, and I had mentioned this matter yesterday, Your Honor, for listing it today. I have a small interim prayer that I would like this
No,
honorable
no,
court to
we'll have
grant.
to see it. On that day, it has not been taken care. No order was passed. Have you
Because
not?
on that day, Your Honor, the prayer for interim was not made. Actually, the petitioner herein, her internship is getting over on 30th of June 2025. That is on Monday. Your Honor, in this case, we are challenging the $15,000 fees interest that has been imposed on the fees of the
No,
NRI
it is
sponsor
listed
quota.
for what? Orders, service
Orders
report,
only.
respect or report is still evident, respond number 1 to 3 also not yet filed by FIDA. You have not filed affidavit.
Will be filing in this the 3 weeks within 3 weeks will be filing. This regarding the petitioner is the student of MEBS There's a criteria and prospectus has been issued with the approval of the government that how the payment, the mode of payment should be made. Now, therefore, the petitioner is against the quota of NRI. The NRI, there's a provision, the total payment is $1 lakh US if without interest, if it is made at make a settlement at one time. If they prefer to make an installment basis, then the criteria for installment has been given plus 15,000 US dollar being interest, my lord. This prescribed, my lord. Now, having accepted this term and condition as prescribed as the criteria for admission, he has taken admission. He is the batch of 2019 to 20. Now he's a verge of completion now. After completing this, having accept this old term and condition, now he's turning around and questioning this, the prospectus condition is developed. This is not tenable, actually.
They have already paid.
My lord.
See, he has already paid.
Yes, already paid. Having accepted his term and condition, he has already
interest
paid.
amount is
Now
low.
he's protesting against that of $15,000, which is which is being charged as an interest, my lord. It is the part of the.
Yes, we'll consider first.
My lord.
What
No,
interim?
my only prayer is that until the disposal of this case, the authorities may be refrained from claiming this particular interest amount. That is the only prayer.
No,
Very,
we cannot.
But
say. If we decide that you are not supposed to pay, or they cannot charge this interest, even if you pay also, you will get it back. If not,
yes, my lord.
you will have to. So interim order is not. And MS so Ralph correspondent petitioner. Office note dated 26/6/2020 indicates that service report in respect of respondent for is still awaited. You have taken steps.
yes,
Yeah. That is 15.5 only. You have taken the steps on 15.5. Mr. Tita learned concept for the learned standing concept for the learned concept for respondent 1, 2, 3. Standing counsel.
Yes, my lord.
Yeah, for respondent 1, 2, 3 is granted for the 3 weeks time to file affidavit. This after 3 weeks.
Deeply obliged.
We consider not. Yes, what is the prayer?
Prayer is that, my lord,
On the prayer yes. What into prayer? What do you want? What is the matter?
my lord, says my lord, my land where the temporary C office is, my lord, has been built, my lord. Now it is deliberated now, and they are going to demolish the structure. I do not have any objection, my lord. And this is the admitted fact that, my lord, the land, my lord, where the land, C office has been constructed, my lord. It has neither been donated nor acquired, my lord. It is the document, my lord, which I have annexed my writ
It's
petition.
very difficult. It's a disputed question of facts. How
My-
do we?
No, my lord, it is not disputed, my lord. There is document in my writ petition, my lord. My lord, may kindly see, my lord.
We'll see, sir. Let them obtain instructions. Well, affidavit, we'll see.
My lord,
It already demolished.
no, demolish, my lord. Let it be demolished, my lord. I do not have any problem.
Then what interim?
No, they are going to construct new building on my land, my lord,
No.
after demolition.
When you are not problem with the demolition.
No, I do not
can
have
we
any
stop the
problem, my lord.
construction?
My lord, that is what, my lord, my interim prayer
Anyway,
is, my
heard Mr. It's for orders.
My lord, since, my lord, this interim order, my lord, could not be considered because they were submitting that they will be obtaining instruction, my lord.
You want that there should not be a new construction
Yes, my lord.
on the disputed land.
No, it is not disputed, in fact, my lord.
Yes, then
My lord, may kindly, I have filed additional affidavit, my lord.
saying what?
My lord, the land, my lord, additional affidavit, my lord, which is filed on, my lord,
Saying what? Showing what?
showing that, my lord, I have applied this through RTI, my lord, whether the land is, my lord, land where the CO office is going to be constructed, my lord, is it, was it ever been acquired, my lord? But the reply of the, my lord, PIO, my lord, at page number 33, my lord, it says, my lord, it was, my lord, may kindly come to page number 33 of my.
Yes, I'm reading. 19 submitted by applicant city care service and to furnish reply to insurance.
My lord, 2 is very relevant, my lord.
In response to the appeal under section 19, what is section 19(1)?
19, my lord, this is regarding acquisition, my lord. Maybe, my lord,
Since
but
the taxing headquarter is not acquired or notified by government for establishment of circle headquarters. Hence,
my lord, this is not only the document, my lord. I have annexed some other document, my lord, which
Where
has
it
been
is?
prepared by the officers of the deputy commissioner, my lord.
What is your claim, sir?
My claim is that, my lord, my father, my lord, has temporarily.
Don't go for what is
Yeah.
your claim? You tell.
My claim is that, my lord, this land belongs to me, my lord.
So
It is my inherited land, my lord.
so
So CO office, no, this administration, this establishment cannot be
without acquisition.
you without acquisition.
I heard Mr. So-and-so, also so-and-so, who prays for it and is granted further 3 weeks time to file affidavit. Next paragraph. Considering that the land claimed by the petitioner is stated to have been not acquired for establishment of
Taxing headquarter.
what headquarter? CO, circle.
CO office.
Circle office, circle headquarter. Come on. Any construction of the, or any construction of buildings, or any creation of any infrastructure shall be subject to the outcome.
My
of
lord.
the petition.
My lord, that will be difficult in the
This will help you.
long run, my lord.
This will help you.
Otherwise, my lord, the community, people of that area, my lord, they are ready to, my lord, give free of cost, land free of cost to the administration, my lord.
So,
But just nearby, my lord. That, and for that, my lord, the
So we
administration
cannot,
is working, my lord.
just blindly stop the creation of infrastructure.
My lord, I'm not saying that my, your lordships may pass this order blindly. My lord, I have annexed the document, supporting document, my
It's
lord.
all right. We'll see. We'll examine.
My lord, may kindly stay there, this,
What?
this, impugn order, my lord.
We say subject to outcome. Or you don't want to be this order. If
At
you
least
don't want also, will not pass.
If my lord is not staying, my lord, this is okay, my lord. Otherwise, my lord, this is a pit case, my lord.
No, we
That-
cannot. How can we stop the development and the establishment of the
That is true, even,
headquarters?
even the
So
petitioner,
where the question of stopping it?
even the petitioner, my lord, we do
See,
not want
at
to stop
best,
the development, my
there
lord.
is a power of eminent domain. We may, if you find that, that your land has not been acquired, and if it is really your land, private land, then we may direct it to acquire and pay compensation. That's all. We cannot stop the creation of infrastructure.
That is
will
true,
be
my lord.
against the
Even the
public.
petitioner, they are ready to this, give free of,
Then delete the last no entry.
no, my lord, that may, let it be remain.
Then
May I please, your lordship?
yes.
My lord, by additional affidavit, my lord, the exact date of delays, number of days of delays has been, my lord, explained, my lord. My lord, after the, my lord, case was concluded, hearing was concluded and fixed for the judgment on 20th July 2024. Subsequently, no date was given. But when we inquired about the, my lord, passing of the impugn order, my lord, then we applied for the, my lord, the copy of the the impugn order passed by the trial court, and certified copy was issued to us on only on, my lord, 14 November 2024, my lord. And from 14 to, my lord, 23 March 2025,
And the total number of days of delay is 129, madam. And out of 129, madam, grace period 90 days has been minus. Then it comes to 39 days, madam. And such delay was caused only because, madam, the department, there is a department procedure. The correspondence made to the Learned Council for the, madam, the department for drafting of the appeal, madam. And during, for drafting of such appeal, madam, it took such days, madam. So therefore, madam, there is no inordinate delay and, madam, the deliberate delay on the part of the, madam, the applicants. Madam, of course, madam, in the department procedure, madam, correspondence after correspondence, in main condemnation application, we have stated everything, madam. So total number of days of delay in filing connected, madam, this arbitration appeal is 39 days, madam. And even certified copy, in certified copy, madam.
When the order was passed?
Madam, the order was passed on 20th July 2024, on which date actually no order was passed. Thereafter, madam, communication has been made to the various branches, wherein, madam, it has been sought for.
So when was passed finally?
Passed, madam, it is also not known when the order was passed. But we
No,
apply.
the date of order is 20/07/2024.
Correct, madam.
Yes, then
There is no, madam, the official record how this order has been passed after, madam, 20th July 2024, madam. Subsequent date was also not given, even no intimation, madam. And on 20th July, no order was passed. It is admitted facts, madam. But
the order reflects the 20th July.
madam, that is the one.
So from where
problem.
you are computing the days delay?
Madam, from the date of, madam, obtaining of certified copy, madam.
When?
On 14 November 2024. On 20, actually, madam, certified copy was given on 14 November 2024, madam. And
yes,
limitation starts run from 15 November to 23rd March 2024, madam, on which date we filed my connected appeal, madam. And
23rd March.
Yes, madam. Altogether 29 days minus 90 days grace period, madam. So total number of days delay is 39, madam.
Well, there is no material on record from where we can understand that this application for certified copy, when the certified application was made for obtaining the certified copy, because they are saying that the order was passed on 20th of July 2024, and on 22nd of July 2024, their representative was present at Bomdila in the court below. But after that, from 22nd of July 2024 till 14th of November, what happened? They have not inquired about the passing of the judgment. They have not mentioned anything in this petition as well as in the affidavit in this affidavit for clarifying the situation, and they have not annexed the certified copy of the order, the impugned judgment and order, to show that when the application was actually made. If we count from 20th of July 2024, since 14th of November 2024, there is a already delay of 112 days plus 39 days. If we go by the by my friend's submission, then it comes to 151 days. And they have not stated a single word from 20. I have stated in my rejoinder affidavit, kindly see paragraph 5, my lord. Today, which I have filed it, they have not stated in their application what has happened from 22nd of July till 11th of November. It is 112 days. They were so negligent that they have not even inquired
not a whisper has been made in the petition as well as in the additional affidavit, what they have done during this 112 days.
When did you come to know the judgment?
Is my lord, we have categorically.
Only on 14.
Only on transfer.
Only on 11 November, my lord. On 11 November, I was furnished the copy of the impugned judgment, my lord. And that was original copy, which has been called back by the, my lord, the office of the learned court below, my lord. And on 14, my lord, true certified to be true copy, lordship will file. I'm sorry, my lord, admittedly, my lord, it is not there. In the main appeal, my lord, page number 778, my lord. I'm sorry, my lord. 77, my lord.
You should have enclosed here.
For 778, my lord. It is bulky, I'm sorry. My lord, admittedly, my lord, no order was passed on 20th July 2000, and subsequently, my lord, it is not known when, on which date the order was passed. Our officers, my lord, always remain present as and when the matter speaks, my lord. They certified to be true copy on 14 November 2024, my lord. It is 778, my lord, 778, my lord, of my appeal copy, my lord. Page number 778, just down below, certified to be true copy, issued by the Solicitor, District and Session Court, Bomdila Division, Session Division, Bomdila. It is 14/11 to 2024, madam. But madam, it is admitted fact that madam, no order was passed on 28th July 2024, madam.
But then when they have applied for the certified copy, that has not been stated. And there is nothing on record to show that they have actually made it.
Madam, applied on 11, as I have stated in my paragraph.
If they have applied on 11th, then there is a delay of 112 days from 22nd of July. They have not stated it.
On 20th July 2024, no order was passed, madam.
They could have applied for certified copy on 22nd.
How you come to know the order? On 11.
On transfer of the presiding judge from Bomdila to UP, my lord. Then we made an inquiry before the Malad authority, Malad court below. On Malad, in the month of November, Malad, presiding judge was transferred from Bomdila, Malad. Then I informed the Malad officer concerned.
How do we know from this that you have applied the certified copy on 11 or 14?
Yes, madam. It is.
From judgment, we cannot, it's not, it's difficult.
Madam.
From the judgment, it's not difficult, it's difficult.
Just for a moment, may I take your lordships to the annexure 1 of my condemnation applications, madam. Application, my condemnation.
Anyway, you fight out in this thing.
Madam.
Merit. Statutory appeal.
That is true, my lord.
You fight out in the what's there.
My lord, in that regard, my humble submission is that the Supreme Court has categorically stated.
What's it?
Yes, madam. One is NV International.
Only one.
Only one. Two in two respects, madam.
The section 37.
Section 37, my lord. Here also, there was a delay of more than 120 days. And the Supreme Court has rejected the prayer for condonation of delay, my lord. I'm reading from paragraph 3. A small judgment. It's from our High Court. Paragraph 4 says beyond 120 days is not liable to be condoned.
If it is more than 120 days.
Yes, my lord, because
129.
admittedly, the judgment was passed on 20th of July 2024. And they have not stated a single word. What they have done from 22nd of July 2024 till 11th of November 2024. For this period only, there is a delay of 112 days. Plus, they are now taking a plea that there is a 39 days of delay. So if we calculate 112 plus 39 days, then it's more than 150 days. 112 days, they have not explained that, whether they have inquired about that or not. From July to November, they have slept over the matter. And they have applied only on 11th of November. Thereafter, they got the certified copy on 14th of November, and they are seeking to get an exemption under the provisions of Section 12 of the Limitation Act from the date of knowledge of the getting the certified copy, by exempting the period from the date on which the judgment was passed. So from the period of 22nd of July till 14th of November, there is more than 112 days delay. Plus 39 days of delay, it comes to more than 150 days delay. And another judgment, I will not trouble your lordship, where it says merely because the government is involved, a different yardstick for condonation of delay should not be laid down. And this judgment of NV International, my lord, to my best of knowledge, this is still holding the field. My lord, I will just refer two paragraphs of this judgment. It's a huge judgment. Paragraph 59. This is referred by Government of Maharashtra Water Resource Department against Borse Brothers Engineering. Paragraph 59, my lord. In fact, I'm not trouble, page 506. Page 506, your lordship has. The last paragraph that starts in 15. The sub-paragraph, sub-paragraph 15. Starts with the law on the issue can be summarized to effect that where a case has been presented in the court beyond limitation, the applicant has to explain the court as to what was the sufficient cause, which means an adequate and enough reason which prevented him to approach the court within limitation. In a case, a party is found to be negligent or for want of bona fide on the part in the facts and circumstances of the case, or found to be have not acted diligently or remained inactive, there cannot be a justified ground to condone the delay. No court could justify in condoning such an inordinate delay by imposing any condonation whatsoever. The application is to be decided only within the parameters laid down by the court in regard to the condonation of delay. In a case where there is no sufficient cause to prevent a litigant to approach the court on time condoning the delay without any justification, putting any condition whatsoever amounts to passing an order in violation of the statutory provisions, and it tantamounts to showing utter disregards to the legislature. Likewise, paragraph 59, it says, likewise, merely because if the government is involved, a different yardstick for condonation of delay cannot be laid down. This was felicitously stated in Postmasters General versus Living Media India Limited. It says, paragraph 27, it is not in dispute that the persons concerned were well aware of or conversant with the issues involved, including the prescribed period of limitation for taking up.
So according to delay, the period will run from which date?
That is the problem here, because they are trying to seek a exemption from the date of their getting the certified copy, that is from 14/11/2024. But they have to, for that, they have to get sufficiently explained from 20th of July till 14/11/2024, which they have not uttered a single word.
What they are saying is there was no judgment at all.
Yes, that cannot be.
But the matter was fixed on 20th.
But they have not also stated that they have applied on during this period.
No, apply is something different. When there was no judgment, how can they apply?
There should be some material that to show that there was no judgment. There should be some, because they are alleging that there was no judgment on 20th of July 2024.
Is there any record to show that it was fixed thereafter? On 20th, there was no judgment. Judgment was not delivered.
But the date of the judgment is 20th July.
22, you appeared.
No, on 20, I personally present there, but no order was passed. If Lordship peruse the Annexure 1, wherein this correspondence has been made to me, my lord. It is, my lord, may I read, my lord, just the contents of the page number 13, Annexure 1 of my condemnation application, my lord. It is intimated that hearing of the subject matter was fixed for judgment on 20th July 2024. However, the same was not held due to unknown reasons. Hence, it is requested to intimate the present positions of the case for further necessary action, please. Subsequently, my lord, no order was fixed. Next page, my lord. Page number 14, Annexure 2, my lord. I'm reading, my lord, second paragraph 2, my lord. It is intimated that hearing of the subject matter was fixed on 20th July 2024 for judgment. However, on 20th July 2024, the hearing was not held, and the present status has been asked from the advocate so-and-so, Guwahati. No information has been received from advocate so-and-so. In addition to the present status of the case is available online on the official website of the Bomdila District Court. It is also enclosed for your perusal. My lord, another letter, it is also, my lord, various letter, my lord, department is corresponding, made correspondings after correspondings, my lord. Even when next date is not fixed, my lord, it is not known when the order was passed. It is very difficult to, my lord, ascertain on which date the certified copy was applied. Then, my lord, certified to be true copy was issued, my lord. 5th December 2024, my lord. This is the last correspondence. Sorry, my lord, not last one. Refer to your opinion that so and so district and so was received on 11 November 2024, my lord. On, my lord. 11 only, my lord. A copy of CTC copy of judgment by Honorable Session Judge Bomdila on 20th July is enclosed herewith, please. And though the law
Where it is?
my lord, page number 15 of my condemnation application, Annexure 3, my lord, I'm reading, my lord. Line of, my lord, line of separate correspondence, my lord, line of, my lord, confirmation is confirmed that no order was passed on 20th July 2024, my lord. Though the order of the Honorable Court is of 20th July 2024, the Union of India could know about the judgment on 11 November 2024 only, man. The Honorable Court set aside the arbitral, the award by the learned sole arbitrator. It is pertinent to mention that on 20th July 2024, the Honorable Judge did not pronounce, madam, very specific, madam, pronounce the judgment. The status of the case has not been shown pending judgment. It is in the e-court portal till October 2024, madam. Even it was not shown, madam. The Union of India, represented by the headquarters chief engineer, Siliguri Zone, and others in opinion to file a contest petition before the appropriate appellate court. Madam, it is clearly mentioned on several correspondence. This copy is, madam, made to so many, madam,
No, when you say that the status of case has been shown, it's shown pending judgment.
Pending judgment, madam. It was not uploaded at all, madam. No date was fixed. When order was
5th of
passed.
December.
Madam, on 20th July 2024, when order was not passed, thereafter there was no any, madam, intimation. There was no even uploading of this.
See, on 5th of
December.
5th of December only, after obtaining the certified copy, only on 11 November 2024, all correspondence has been made, wherein clearly mentions that the copy was only available on 11 November 2024. Certified with true copy was, again, this original copy was called back, and on 14 November 2024, only certified with true copy was issued. Applicant petitioner, since this is a statutory appeal, and moreover, it is not known when the order was passed. On first date, when the matter was not passed, it is very difficult to know when it was passed. Once one hearing is skipped, subsequent date is subsequent date when the order will be was passed was very difficult, and there was no any correspondence. But only we came to know, as we have categorically by affidavit, we have stated in our paragraph, that we came to know only when the presiding judge was transferred to UPR from Bomdila. That is only in the month of November. And it is fair to make submission. When 20th July, when on 20th July 2024, when order was not passed, on which date the order was passed, it cannot be ascertained, madam. Just we only ascertain when the presiding judge was transferred in the month of November. So therefore, there is no ordinate delay, madam. Admittedly, madam, 39 days of delay took, madam, for preparation of several correspondence, madam. It is bulky, madam. That of course, entire thing has not been stated. But for that, for drafting, my lord, and correspondence, my lord, it took such day of delay.
Minus the 30 days.
Yes, my lord. So, my lord, it is a reasonable date, not
My lord,
the
kindly-
125, my lord.
Kindly see
Number
their
of days is 29.
internal
Okay.
documents from their internal documents, annexure 2, page 14.
Just a moment, my lord. My lord, I have not gone through the judgment placed by the my lord, the learned friend. But if that judgment is relied upon, my lord, it is, my lord, in our case, number of days of delay is 39, my lord. But just what I have heard, if I am not wrong, my lord, it is 120 days, more than 120 days, then just my lord, the delay cannot be condoned. But in our case, only 39 days, my lord. Delay is 39 days.
That too after additional affidavit has been filed. In the main application,
Therefore, my lord, just to clarify all these things, my
in the
lord, we
main
file
application,
additional-
there,
Tell us, you find out in the appeal, what's there?
my lord, because there are some serious negligence and laches on the part of the applicant.
No.
That is why we are all.
directly they cannot be attributed to us, my lord.
They
This is
may not
the
have, serious negligence, we can say.
And even they have not annexed the certified copy along with the continuation of application, delay application.
that is already in the main appeal.
Are you seriously objecting?
I am seriously objecting, my lord.
Third, Mr. M. Kato.
Because of that, only for that Supreme Court judgment, otherwise I could not have.
That is only 150, 120 days, my lord. But in our case, 39 days only.
Otherwise, suppose if we take it from 14/11,
Yes.
the delay is 39 days.
Yes, ma'am.
14/11 till 23rd of March.
Then 11 July, their communication.
Correct.
That is
Yes.
And Mr. for
But,
applicants, huh? And Mr. Applicant Union of India. And Mr. Eder.
Yes.
Learned Council for. Respondent number. For opposite.
All the respondents.
All the opposite party.
Opposite parties and respondents. This is an application under section 5 of limitation. Will it be under section 5?
Yes.
Indian Limitation Act 1963. Praying for condonation of 39 days delay in condonation delay of 39 days in filing the connected arbitration appeal being arbitration appeal number 01 of 2025. Assuming the judgment and order dated 20/07/2024. Passed by the district judge, West Caming District, Bombela. It's in miscellaneous arbitration case number.
Yes.
Case.
Arbitration miscase arbitration case number 1, 2020.
Misc arbitration case number 01 of 2023.
23.
Miscellaneous arbitration case number 01, 22.
You are the applicant in the arbitration case number 01.
Yes, my lord. It is against the award dated
Okay.
24th
The-
of
the-
February.
Respondents filed an application under section 34 of the Arbitration and Conciliation Act 1996, assailing the arbitral award dated 24/02/2023 was by the sole arbitrator, Justice
BK Sharma.
Mr. BK Sharma, within bracket, retired. In arbitration proceeding number 16 of oblique PS MES oblique 2021, which was registered as miscellaneous arbitration case number 1 of 2022 before the learned district judge Mobdila. Mr. The learned district judge Bomdila has passed the appeal under section 37 of 37 of section 37 of Arbitration and Conciliation Act 1996, for which a delay for which there is a delay of 39 days in filing the connected appeal list of Mr. M. Kato, learned counsel for the petitioner, while explaining the delay, submits that in fact no judgment, the order judgment and order dated 27/07/2024 was not pronounced by the learned district judge Bomdila as the representative of the applicant has appeared on the day on 22/07/2024, since there was no judgment was pronounced on 22/07/2024, and correspondence were made between the authorities and the authorities and its council. Mr. The correspondence clearly indicates that till third of October, till the month of October, there was no the website of the district court shows the case, the status of the case to be within inverted, judgment, pending judgment. Mr. He submits that it is only on 11/11/2024, the applicant came to know that the judgment and order has, oh, no, the dated 20/07/2024 has been delivered, Mr. When did you apply the certificate copy?
Certified copy, my lord, there is a 11/11/2024, on which date original was given without CTC, my lord. Then immediately call back on
He
14.
submits that on 11/11. The applicants applied for the certified copy. However, the certificate copy, pursuant to which a copy of the judgment and order was furnished, was issued. However, since there was no, however, same was not a certificate copy, therefore it was called back, and accordingly, and finally, on 14/11/2024, the certified copy of the judgment and order dated 20/07/2024 was issued. Mr. Next, Mr. Kato, learned counsel for the petition, learned counsel, learned DSJ. You'll be addressed as a DSGI.
My lord.
DSGI. But it submits that. On receipt of the certified copy, the authorities of the applicant, the authorities made correspondences, correspondences for advice and suggestions with regard to the judgment. Mr. Which has taken a considerable period of time. Mr. Finally, after preparation of the appeal, the arbitration appeal under section 39 would be filed on when?
23rd of March.
23rd March.
25th. 2025.
2024. List of in the process, for which there is a delay of 39 days in filing the connected appeal. If the grace period of, if the period of 30 days, 90 days.
It is
The period of 90 days.
90 days.
90 days, man.
As per the limitation period is taken off.
Yes, man.
Yes. Therefore, he submits that the delay of 39 days may be unknown. On the other hand, Mr. Ed had done counsel for the respondents. Submits that the applicant has failed to show that failed to show that why when he has applied the certified copy of the judgment and order dated 20/07/2024 as then all copy annexed to the is not annexed to the present application And the copy annexed to the appeal doesn't indicates the date of application for the date of apply for certified copy. Mr. He submits that there's no mention, much less the explanation from 22/07/2024 till 11/11/2024. I 112 days to justify that there was no negligence or deliberate negligence, negligence or in a deliberate inaction on the part of the applicants. Mr. Therefore, Mr. That apart, even the 39 days projected by the applicant has not been explained properly, has not been explained at all as to whether there was a sufficient ground to sufficient ground to condone the delay. Therefore, he submits that the appeal being an arbitration, the application, the appeal being under Section 27 of the Arbitration Conciliation Act. The and the arbitration proceedings and the object of arbitration proceedings being of speedy resolution of all arbitral disputes. Same cannot be. The delay cannot be condoned. Delay is not the delay in filing the appeal cannot be condoned. Cannot be condoned. Mr. In support of his submission, he has placed reliance on the judgment of the Supreme Court, order of the Honorable Supreme Court. In the case of NB International versus State of Assam and others, reported in 2022 SCC 109. Report the FERA 3 and 4. Huh? And number 2, Government of Maharashtra versus Borse Brothers Engineers and Contractors, reported in 2021 6 SCC 460. Para 59.
Yeah,
Only 59.
only 59.
58, 59.
58,
58 also.
58 and 59.
We'll take the relevant. You just quote the 58 and 59. We'll see and take the relevant one. 58 and 59. I've considered the submissions of land council for the parties. Also very the reasons put forward in the application. For filing the connected appeal. And then in not filing the connected appeal within reasonable period, within a limitation period. Mr. The learned district judge, Bomdila, West coming, from Bomdila, has disposed of the arbitration, a miscellaneous arbitration number 01/2023, which was instituted by the applicant. You are the one who has filed a miscellaneous arbitration.
No, they.
By the opposite party. Against the arbitration award dated 24.
2/2/23.
02/2023. In the proceeding, in the arbitration proceedings, number so and so, huh? Sure. Records reveals that the judgment and order dated 20/07/2024 was not pronounced on the same day as the representative of the applicants was present on the said date listed. The various correspondence between amongst the authorities, including the London DSGI, indicates that till 3rd of October, the status of the case, a miscellaneous arbitration case, was shown to be pending judgment in the old website of the District Court. Mr. Although the petitioner, the applicant would have required to explain the 112 days completing from 22/07/2024 to 11/11/2024, since the extent that they came to know the judgment and order only on 11/11/2024. There was no the explanation, if provided also, may not be relevant in the facts of the present case. Mr. This court finds that the applicant has applied to certified copy on 11/11/2024, and the same has been issued on 14/11/2024. . I am of the, no, it can be said that the delay of 39 days projected by the applicant is genuine. List of the orders, the reasons of delay in filing the connected appeal appears to be reasonable in as much as the department authority and it involves the different authorities to take a decision on the issue, the decision on the issue as it involves the interest of the department and not related to one single officer or officials. List of. That's why I find that this explanation to be sufficient, which prevented the applicant to file the connected appeal within the period of limitation. Mr. The judgment and order of the Honorable Supreme Court in the case of so and so as relied on by parties with regard to having been regard being had to the judgment order so and so by the Supreme Court relied on by learned counsel for the opposite party. On the parity, the facts of those cases are distinct and different. The case of so and so is rendered so and so in both the cases. I'll distinguish. It is settled proposition of law that when the substantial justice and so, I'll give that. We'll continue.
That is rising.
Where are aligned here?
Well,
all right.
and
I'll explain it.
Sure, definitely.
Running sort of.
The copy of the memo of appeal then be served.
Developer. And my lord, there are some hearing.
I think it's maybe difficult. If there's urgency, we'll come back. We have a reference now.
Yes, yes, I understand that.
After the case.
After.
All the cases.
All three cases, 30, 31, 32.
Or Mr. Deepang learned counsel for the petitioner. In all the cases. Separate orders. In this 30 and 31, you same one order. 30, two separate order. And Mr. So and so, who are appearing? Who is appearing in
30 and 31, learned senior counsel today, but he's not here today.
Anyway, this due to paucity of the matter could not be taken up as agreed to by the parties. Then this matter listed after 4 weeks.
Oh, yeah. Problem.